Okay, so the state charged Awad with driving under the influence in violation of OCGA section 40-6-391 parentheses lowercase a parentheses 2, improper stopping in violation of OCGA section 40-6-203 parentheses lowercase a parentheses 1 parentheses uppercase c, and failure to wear a safety belt in violation of OCGA section 40-8-76.1, which that seat belt is only a $15 ticket. Now, I have never paid one. I used to get tickets for no seatbelt all the time. And I will tell you what I did to get out of these seatbelt tickets, because really they shouldn't even be pulling you over for not wearing a seatbelt, because it's your choice. You know how these liberals scream, my body, my choice. Well, my choice to wear a seatbelt or not. The state has no right to be concerned about your safety because they don't care. It's all about money for them. And that's what municipal courts are. They're money mills. If you ever see a municipal court, it's filled up with people with tickets. If everybody that went before the judge said to the judge, I demand a trial by jury, that's all you got to do. No municipal court would make any money, and they would shut them down. And that's the goal, to shut these courts down. You need to shut down money mills. And that's all you got to say is, I demand a trial by jury. It's your right. Even on a seatbelt ticket, it's your right. Are they going to spend hundreds and hundreds of dollars to do a jury trial for a seatbelt ticket that's only $15? Exactly. So that's why I'm saying, you know, we need to start getting rid of these money mills, these municipal courts, and then police will stop writing all these tickets. They'll write fewer and fewer because the state and superior courts are not going to want all these tickets in their court.
Well, I can't go anywhere, can I?
That's why municipal courts were born. And I'm sorry, I have a passion about this. I don't ever want to see anybody paying on tickets. And the worst excuse I've heard about people paying tickets is, well, I don't have time to go to court. Yeah, no, but the state has time to take your money. And now that you pled guilty and paid on a ticket, what they're going to do is they're going to pay attention to you, because they know now you will pay tickets. So they will pull you over more and more and give you more tickets, and you're going to keep paying them. And then what's going to happen is you're going to run out of money, and then what they're going to say is, oh, you can't pay? Okay, we're going to throw you in jail.
Okay, I'm leaving.
Which is another thing they can't do. Oh, God. I mean, you have to understand the way these things work. Okay? And that's why I say reading the Georgia State Constitution, everybody should do it. Everybody should do it, know it, learn it, because it's very important.
He's sitting out.
They have a paragraph in there. I believe it's Article 1, Section 1, Paragraph 23, that says, there shall be no imprisonment for debt. Now, if you owe on a parking ticket, that's a debt. Or if you owe on any ticket, that's a debt. Yet the courts continuously threaten you with jail if you don't pay it. But in reality, you don't have to pay it. And they can't throw you in jail because it's a violation of the Georgia State Constitution. People need to see this. These are things that people need to learn. Now, it says, sorry, that's just my alarm letting me know that my blood sugar is high. Before trial, Awad moved to suppress his refusal to submit to the urine test under paragraph 16 of the Georgia State Constitution. Relying on this court's decision in Elliott, the trial court granted the motion. The state immediately appealed. See OCGA 5-7-1 parentheses lowercase a parentheses 4. And the Court of Appeals reversed. see State v. Awad. And they have the appellate number for that, and that was in 2020. We granted Awad's petition for certiorari to determine whether the trial court erred in concluding that the state was not permitted to introduce into evidence Awad's refusal to provide a urine sample on the ground that admitting such evidence would violate his right against compelled self-incrimination provided by paragraph 16 of the Georgia State Constitution. Paragraph 16 provides that no person shall be compelled to give testimony tending in any manner to be self-incriminating. Any manner. Any. Breath, blood, urine, saliva, nothing.
How are you gonna do that?
Although the language of paragraph 16 references only testimony, we concluded in Olevic that the provision's long history of interpretation showed that its scope was not limited to evidence of a testimonial or communicative nature. And they see Olevic. In addition to prohibiting the state from compelling a defendant to give self-incriminating testimony, we explained paragraph 16 prohibits compelling a suspect to perform an act that itself generates incriminating evidence. Beautiful. And the Georgia Supreme Court is reading the Constitution the way it should be read. Applying this principle, Olevic held that paragraph 16 protects against compelled deep lung breath tests and affords individuals a constitutional right to refuse testing. And then they say see Olevic with the case number there. This was so, we explained, because for the state to be able to test an individual's breath for alcohol content, it is required that the defendant cooperate by performing an act. And they have that in quotes. Namely, by blowing strongly, deeply, and unnaturally for several seconds in order to produce an adequate sample. And then it says ID at 243 and 244. Although exhaling breath generally occurs involuntarily and automatically, we noted sustained strong blowing into a machine for several seconds requires a suspect to breathe unnaturally for the purpose of generating evidence against himself. See what I'm talking about? And now, the Georgia Supreme Court gets it right here every time. Accordingly, if the state compels a defendant to submit to a breath test, paragraph 16 prohibits the state from admitting into evidence any incriminating test results. CID at 252, affirming the denial of a motion to suppress the defendant's breath test results because although paragraph 16 protects against compelled breath tests, the state had not compelled the defendant to submit to the test. Now, and that's exactly what I'm talking about. The moment you agree, which you should never do, the moment you agree to a test, that's on you. All you have to do is say, no, I refuse, I refuse, I refuse, I refuse. I don't answer questions. I don't take any tests. Let me go. And if they arrest you, they arrest you. They can charge you with DUI all they want. They have no evidence to prove that you were under the influence of anything. Unless you say, okay, I'll take it. Just refuse. Refuse anything. No matter how much they threaten you, if you refuse, we're going to arrest you. Fine, arrest me. Because they still have no evidence against you. And that's the key. They have no evidence against you. They just can't go into court and say, yeah, we assumed he was drunk. They can't do that. That's not how the law works. Now, where were we? Whereas Olevic addressed when a court should suppress compelled breath test results, Elliott considered when a defendant's refusal to submit to such a test should be suppressed. and then it says see Olevec and Elliott. Declining the state's invitation to overrule Olevec, we have reaffirmed Olevec's holding that paragraph 16 affords a defendant a right not to be compelled to submit to a state-administered breath test and a right to refuse such a test. So, the Georgia Supreme Court is telling you to refuse it. That's what they're telling you. You refuse any test. No field sobriety test, no breath test, no blood test, no urine test, no saliva test, nothing. That's it. You flat out refuse.